Okay, good evening. I decided to do this webinar because I had a client recently ask me the question about an entity and what the different entities would or would not do for him. So I thought it was time to review this question yet again. So I am going to do a screen share. I have a little fancy PowerPoint for you all, and let's get that up. And let's expand that and start at the first slide. Let's go to the first slide. So the entity choice question, and this is a presentation that I've given before multiple times, mostly in person, but I decided to go ahead and record it for everybody because I'm not doing a lot of public speaking for obvious reasons. It's 2022 for anyone who might be viewing this in the future. So disclaimer, nothing in this presentation is intended to be nor should be taken as legal or tax advice. The information contained herein is generally informative in nature and does not necessarily apply to any specific situation or legal need. Attendance at this presentation does not create an attorney-client relationship nor an expectation of confidentiality regarding anything you may disclose to the presenter for those people who are attending live or for any comments that you might provide later. So a lot of people think, the legal myth, an LLC is always the best choice. The LLC is kind of the entity du jour these days. But it is not always the best choice, and particularly in California. Oh, here comes my assistant to give me a hand. She'll be just over here in a minute. Come here. Let's see. Come here. Come here. This is Princess Grace of Monaco, who has to be present at all presentations. So the basic three common entity forms that we look at in business, and the businesses that I deal with, which are mostly founder-owned and operated businesses, sole proprietor, S corporation, and LLC. There are others, and we'll kind of dive into some of those others just peripherally, but these are kind of the three main entity structures that people use when they're in that kind of startup or founder-owned and operated phase. As a sole proprietor, why do we not want to be a sole proprietor? Because you pay a lot in taxes. So all of the revenue that from the business that ends up in the owner's pocket is going to be subject to income tax at whatever tax bracket you're in, and employment tax, which is about 15.8%. I think it's less than 15.5, but we'll just use this number for purposes of this presentation. General partnerships are sole proprietors of two or more people. And there are other challenges that arise when you have two or more people. But as far as revenue flow, this chart applies the same to general partnership and sole proprietorship. All revenue that ends up in the founder owner's pocket is subject to income tax and self-employment tax. So it also exposes the owner or owners of the business to liability of their personal assets being accessed to satisfy liabilities of the business. Your house, your car, your bank account, whatever assets you personally have. And if it's a general partnership, that liability crosses between you, because as general partners, you are jointly and severally liable for what one another does in the course and scope of operating the business. So there's liability issues and tax issues that we are addressing when we decide what kind of an entity to set up. We also want to ask, what's our exit strategy? Because that can impact the type of entity we want to set up as well. So in an S corporation, you've got one or two or more owners, and they are the shareholders, owners of the S corporation. Now the same revenue comes in to the entity, and first stop is tax write-offs. There are a few extra tax write-offs whereby the owners can benefit from expenditures on a pre-tax basis. Then that rest of that chunk that's going to end up in the owner or owner's pockets will be split into two buckets. the reasonable salary bucket and the shareholder distribution bucket. The reasonable salary we just follow this arrow over here and then down, will be also subject to income tax and payroll or employment taxes. But there's another portion of that revenue that will be given to the owner or owners as shareholder distributions. That revenue is not deemed, that's your share of the profits as an owner. It is not deemed pay for work that you do in the course of the corporation. And so that's only subject to income tax. How do you split this out? Talk to your CPA. This is where you need specific legal and tax advice. I personally always pay myself a little bit more on the payroll side than the shareholder distribution side, because I've been advised that will satisfy the IRS. It doesn't raise red flags, in other words. However, I'm not giving specific legal advice here. This is something that you want to talk with your attorney and your CPA when you're setting this scenario up. So the tax savings in the S corporation are that you don't pay that payroll tax amount that you would have paid in the general partnership or the sole proprietorship on all of the revenue that is ending up in your pocket that's distributed to you. You're going to just keep that shareholder distribution portion segmented out, and that is only going to be subject to income tax. As far as liability, we talked about being in a sole proprietorship or a general partnership where your house, your car, your money are all subject to liabilities in contract or in tort, meaning if you get sued for breach of contract, or if there's some negligence issue, most commonly thought of would be trip and fall, but it also could be, employer liability for some kind of protected class tort. A tort is a legal wrong that is not covered by the criminal code. So it's a civil wrong. You get this corporate veil of protection. We've heard of the corporate veil that protects your personal assets over here from any liabilities that arise out of the course and scope of the business. So you get tax protection, reduced tax liability, and you get personal liability protection for your personal assets with a corporation. So let's see. Yeah, LLCs. Okay. So the question is, how do you decide, this is a 2016 PowerPoint. I kind of forgot. The question is, how do I decide which entity to choose? Well, we do a liability assessment of the business and your personal assets. What do I have to lose? What are my personal assets? How risky is my business? And then we look at taxes. What are you paying in taxes now? And I have a magic number that I advise my clients, and I'm not going to give that to you now because I'm not giving specific legal advice, but CPAs are really good at providing advice in this area, as are business lawyers such as myself, for your specific business. And what is that cutoff point where the tax liability, the taxes you're paying now as let's just say you're a sole prop or a general partnership, when is it time to shift over to that corporation? Because there are fees, maintenance fees, to keep that S corporation alive. And those include in California, the $800 to the California Franchise Tax Board for the privilege of having a registered business in California. There's $25 for your statement of information. You have to pay somebody to do your minutes, like me. I charge like $150 for a solely owned business for minutes and statement of information. So let's just say that's 150. So now we're almost at 1,000 there. And then you'll have to have a corporate tax return filed. And that is going to be, a fee that you'll pay to your CPA, which right now is around, $800 to $1,500, depending on who you're using and how complicated your business is. So there are costs to maintaining this thing. So you look at, if you have high liability or you have co-joint ventures, meaning you're in business with other people, because remember that joint several liability that I mentioned, where you're liable for the acts of the other, or if you're in a high liability business like a bail bond company or private investigators, or contractor where you're doing work on people's homes, or a martial arts studio. These are high liability businesses. This is the assessment that I engage in when I'm determining whether it's time to set up an entity. So then we ask, well, what about LLCs? Everybody thinks that's they're the latest and the greatest, but what the heck are they and when do we use them? Well, the evolution of law is like a dance. If you know me, you know I'm a dancer. This is a Martha Graham, an iconic Martha Graham picture. The law evolves over time to address the needs of the business public. Initially, liability assessment was an issue, and that's why corporations were even created in the law. And this entity law, this corporate law, goes back to Old English law before the U.S. was even founded. So, a lot of our law in some states like Louisiana comes out of French law, but most of the U.S. law comes out of English law. So there was liability for sole business owners to be in business for themselves, and they wanted the law put in place a mechanism by which they could sequester their personal assets from liabilities of the business, and corporations were developed. But then I'll go back to this slide. Then there were this double taxation, which you may have heard of. So the business itself, the corporation profits were taxed, and then when they were distributed to the owners, the shareholders, they were taxed again. So this S corporation entity was created as a legal mechanism whereby, with certain restrictions, a smaller business could have a flow-through tax status whereby the profits were not taxed at the corporate level, but when they flowed through to the owner in the form of those shareholder distributions, the owner would pay income tax on them. But this was designed to be for smaller businesses. So right now in California in 2020, this is limited to 100 or fewer shareholders, no entity shareholders. So you can't have another corporation or an LLC be the shareholder. It has to be just human persons. No non-US shareholders, and you can only have one class of stock for purposes of shareholder distribution. So you can't have preferred distribution. That gets into a complex concept, which this webinar is not designed to address. So let's just go on to LLCs. So LLC gives you the same liability protection in tort or in contract. It gives you that same veil called a company veil in this instance. But the tax issue is a little different. So when forming an LLC, when you get your EIN, apply for your EIN, you're going to choose whether you want to be, if you're a sole owner or a married couple, you can be disregarded for tax purposes, but still maintain that liability protection. You can be taxed as a partnership if there are two or more individuals who are not married, and or you can be, check the box to be taxed as an S corporation. So now you have the LLC structure, but you're being taxed as an S corporation anyway. So you might as well have set up the S corporation in the first place, because there's no real advantage to, in my opinion. I like corporations better because they're more formalized and there's a little more record keeping. And that provides better evidence of adhering to corporate formalities. Failure to adhere to corporate formalities leads to piercing of that corporate veil and having a judgment creditor have access to your personal assets that are protected by that. Remember that red curtain, that are no longer protected by that red curtain. There's alter ego liability and failure to adhere to corporate formalities. That's failure to keep separate bank accounts, failure to keep proper record keeping. And there's specific record keeping, like the minutes, that are required in corporations that just provide extra evidence of adhering to those formalities. So for these reasons, I like them better. Additionally, in California, upon initial filing of a LLC, the client pays the $800 to the California Franchise Tax Board within the first 75 days. For corporations at this time in 2022, you get your first calendar year free. So it's February of 2022. If I set up a corporation in California now, I wouldn't have to pay my first $800 to the Franchise Tax Board until 2023. If I set up an LLC today, I'm going to pay that 800 starting April of this year and April of the next year. So there's just lots of nuances as to why to choose one or the other. So if an LLC elects to be taxed as an S corporation, you can still engage in this split where there's reasonable salary that's subject to income tax, and then there's a member distribution. The reasonable salary is subject to income tax and employment tax, and member distribution, which is only subject to income tax. You're operating just like an S corporation. But you still have, but an S corporation has certain limitations: 100 and fewer owners, no entity owners, no foreign owners, no preferred distribution plan. The one advantage to having an LLC without the S corp limitations is that you can have more than 100 owners. You can have entity owners. You can have foreign owners, and you can indulge in preferred distribution if you don't take that S election in the LLC. So in some businesses, LLCs were really mainly developed to kind of take the place of the old limited partnership. In the old limited partnership scenario, those were really designed for flip deals where you create something like a movie or a record album or a real estate project, and you don't make any money until you sell the thing, right? As opposed to an operating business where you generate revenue by selling those products or services ongoingly. The limited liability company, the limited partnership was designed so that people could invest money into a project, but the only thing they could lose was the amount they invested into it. Those are the limited partnerships. They had that liability protection that we're talking about with that corporate veil, but they weren't subject to corporate tax on capital gains. So I'm getting a little circuitous here, but if you sold a project like a movie, a record, a real estate deal out of a corporation, your revenue that you gain is deemed capital gain, and you're subject to corporate capital gain rates, which are higher than personal capital gain rates. So the limited partnership created a scenario where those limited partners who put money into the project had liability protection by their participation, and the revenue that they earned from selling the movie, house, shopping center, record, whatever, would only be subject to personal capital gains. But the challenge with that was that the general partner would have personal liability for his or her personal assets. So that person would then form a corporation to serve as the general partner. And now you have a double entity structure, which is like 2 tax returns, 2 times $800 to the California Secretary of State, and 2 separate compliance filings. So the LLC was kind of created as a hybrid between the S corp and the limited partnership, so that it could provide that opportunity for people to invest into an entity, have liability protection, and not have a double entity structure, and still be able to enjoy those individual capital gain rates, not corporate capital gain rates. I've also used them when there's investors into a business and they wanted to use an entity as their shareholder, let's just say. So in LLC, shareholder equates to member. So for an ongoing operating business that sells, that derives revenue from, daily, weekly, monthly selling of a product or service, not capital gain, one reason to use an LLC would be if you had foreign owners, more than 100 owners, non-entity owners, or you wanted to create some kind of preferred distribution plan. For instance, owners come in and they buy in at an equity price of, let's just pick a number, $100,000. So I buy in I want to buy in as my own corporation. My corporation is going to be a member of this LLC, and I'm going to contribute $100,000 to this business. So my deal with you all is that with the other co-joint ventures or with the LLC, is that when we start doing profit distributions, I get paid back first. I'm a preferred recipient of distributions up to my initial investment, $100,000. And then we do the pro rata split. In an S Corp, you have to do the pro rata split regardless of who put money in first or who put the most money in. It's pro rata based on your percentage of ownership. So I hope that made sense. So if an LLC elects to be, well, if it elects to be taxed as a C Corp, then you are going to also pay tax at the corporate level, just like a C Corp would. You'll have write-offs, you'll have reasonable salary on which you pay payroll tax and income tax, but the shareholder distribution, the profit, this is the same for a C Corp, or if the LLC elects to be taxed as a corporation, but doesn't take that X election, there's corporate income tax that comes out first before you as the owner gets your distribution. So it's taxed here and then it gets to you and then it's taxed and we don't know what your income tax, that's all based on your tax bracket. So that kind of explains the entity structure and why we would do it: liability assessment and tax assessment. So if an LLC elects to be taxed as a partnership, then it's going to be just like a sole proprietorship, or so that all the revenue is going to be subject to income tax and employment tax, right? Like in the very first slide where I started talking about that. So being taxed as a partnership, you can put the two together. If you're getting revenue ongoingly from operating the business, right? Then you'll be subject to these two taxes. If your revenue comes from flipping the deal, selling the album, selling the movie, selling the house, selling the play, selling the book, whatever it is, whatever the project is that people are investing money into, and then the revenue is derived from the sale of the thing, then you don't have employment tax, you only have capital gains tax. You don't have income tax, you have capital gains tax. So it gets complicated, but you can kind of see that. I mean, the biggest point I want to make is that it's not just everybody chooses an LLC or everybody chooses an S Corp. It requires a knowledgeable liability and tax assessment, and also an exit strategy assessment of a particular business or project to determine what entity is appropriate. I talked about the franchise tax board, the downside of an LLC, you pay that the first year, and the franchise tax can be, this is why it's best used for that flip deal where you're getting your revenue all at once when you sell it, and then the LLC dissolves anyway, because the franchise tax can increase based on gross, not net. So if there's ongoing gross revenue, the franchise tax for an LLC can increase exponentially, regardless of whether there's a profit or not. So there's fewer formalities. Some people like that, but that provides less evidence of adhering to company or corporate formalities. The upside is you have the corporate veil liability protection. It's a flow-through entity, just like an S Corp, no corporate capital gains. This is the big thing that I look at when I'm looking at why we would do an LLC. So don't buy into the myth that the LLC is the best in every scenario, and don't let any entity choice be a guessing game. Get legal advice, get tax advice, analyze, customize to your specific scenario, and minimize your risk. And as with any presentation that I do, you always get the end of the wolf to show that this is the end of the presentation. And I always like to point out a little wolf trivia. Wolves have long, skinny legs, and all wolves in the US are known as gray wolves. And they may not look gray on the outside, but their undercoat. So this is, you see this wolf is got kind of a mottled coat, many different colors. And those are the guard hairs. And those guard hairs are always there, but the undercoat that keeps the wolf warm and waterproof in the wintertime sheds out in the spring, and those hairs are always gray. That's your wolf trivia for tonight. I hope you have a lovely evening, and thank you so much for joining.